Good afternoon. I'm Henry Weinstein, one of the professors at University of California, Irvine Law School, and I'm here to talk to our Dean Erwin Chemerinsky about his new book, The Conservative Assault on the Constitution, which has just been published. Erwin, why did you decide to write this book now, and how long have you been working on it?
I've always wanted to write a popular press book. I wanted so much to communicate to people the effect of conservatives on constitutional law. Since Richard Nixon ran for president in 1968, conservatives sought to change almost every area of constitutional law. And what I wanted to explain was to the extent they've succeeded and what it means for people's lives.
Right. You cover a whole range of subjects in this book, relating from terrorism, elections, and so on. But there's one case I'd like to talk to you about at first that I found to be maybe the most poignant thing in the book. When I think of, to me, what's perhaps the most important Supreme Court case of the 20th century, it's Brown versus Board of Education, which called for an end to segregated school. But you say in the book that there has been an incredible retreat on this front in this country, and that the picture is very gloomy. And in fact, you have one sentence that's really striking. You say the tragic reality is that American schools are separate and unequal. To a very large degree, education in the United States is racially segregated. Could you talk a bit about that?
Statistics show that every year American public schools are more racially segregated. Statistics show a tremendous amount less is spent for a black child, a Latino child's education than a white child. If we're ever going to be equal as a society, it has to be through education. And the point I'm trying to make in the book is that the Supreme Court decisions from recent decades have led to separate and unequal schools.
Okay. One of the things that you do in the book that I think is quite significant is you don't talk about this merely as a judicial phenomenon. You say that what judges who have been appointed by presidents, starting with President Nixon and going to the public, fit into a larger picture that was sort of by design to cause a retreat in some of societal advances. Could you sort of talk about the judges in the context of the overall posture of your book?
And you're absolutely right. It is one of the themes I want the book to emphasize, that I think you can only understand what the Supreme Court is doing in the context of the larger conservative agenda. Starting with Richard Nixon, all of the Republican presidents, all of the candidates for the Republican presidency have wanted to remake constitutional law. And what I want to say is their agenda has largely succeeded. Sometimes it's their own policies, such as what President Bush did in expanding executive power. To a large extent, it's with the justices they appointed at the Supreme Court and the judges they appointed at lower federal courts. And what I want to communicate is we're not dealing here with moderate conservatives. When we're talking about presidents like George W. Bush or Ronald Reagan, or justices they appointed like Antonin Scalia or Samuel Alito, we're talking about people fairly right on this ideological spectrum. And they've had a tremendous effect in changing constitutional law. It affects everybody, even in their day-to-day lives.
The first chapter of your book, which deals with three strikes, is a picture of a Supreme Court, or at least a Supreme Court majority, that seems to be utterly lacking in empathy, and I was wondering if you could talk a little bit about that.
Sure. Let me start with the case. It's a case that I handled in both the Federal Court of Appeals and the United States Supreme Court. My client, Leandro Andrade, was sentenced to life in prison with no possibility of parole for 50 years for stealing $153 of the videotapes from Kmart stores in San Bernardino, California. He received that sentence under California's three strikes law, even though he'd never committed a violent crime. No one in the history of the United States has ever received a life sentence for shoplifting prior to California's three strikes law. And yet I lost 5-4, with the conservative majority saying that it is permissible for states to impose such punishments. I agree with you. It shows a shocking lack of empathy. I believe we want judges to have empathy. I remember when critics were attacking President Obama for saying he wanted justice with empathy, and I think, isn't a person without empathy a sociopath? And do we really want sociopaths on the bench? Judges and justices have tremendous discretion. And one of the things we want them to consider is, what's the human effects of the decision? Obviously, they have to look at the text of the Constitution and the original understanding and historical practice and tradition. But I also want them to be looking at what the rules mean in terms of people's lives.
And also, doesn't that decision, it seems to me in some ways, both kind of almost eviscerates the Eighth Amendment, which stands for you should not have a cruel and unusual punishment imposed on you. And then also, I'm just also curious about an issue of consistency here. In recent years, there are certainly some members of this court who have talked a lot about the need to reduce punitive damage awards won by individuals against large companies on the ground that it's a violation of their due process. Would it be fair to say that there's a greater concern about corporate pocketbooks than somebody going to jail 50 years for $150 worth of videotapes?
As you know, in the 6th chapter of the book, I talk about the restrictions on access to the courts. And I talk about another case that I argued and lost, though this is in the California Court of Appeal the same year. It was about the Ford Bronco, and it was about a family that was in a horrible accident where 3 of them died and 3 were seriously injured because the Bronco was rushed to market without safety precautions. And a jury awarded them $290 million. An earlier Court of Appeal decision accused Ford of being, in a sense, guilty of manslaughter in what they had done, taking this risk knowing that it would lead to deaths. And the court tremendously reduced the punitive damage award in my case. And I said I didn't have to be a cynic to think that if you put together what we're talking about, it's too many years in prison for shoplifting doesn't violate the Constitution, but too much money in punitive damage from a corporation does. That's not what I think the Constitution should be about. And one of the reasons I wrote this book was try to communicate that to people. I remain very hopeful. I conclude the book by saying, if you look at the sweep of American history, there's been tremendous advances with regard to equality and liberty. We've gone from a society with slaves, to a society with Jim Crow laws, to a society of segregation, to one that at least aspires to racial equality. We've gone from a time when women were chattels of their husbands, to where women couldn't vote, to now a society that values equality for women. We can think about just the advances with regard to gay rights, from homosexual activity being illegal, to the Supreme Court protecting the right to engage in private homosexual activity, to now perhaps we're on the verge of marriage equality for gays and lesbians. I could do the same story with regard to liberties. I believe that the period in which we're talking about, 1969, the election of Richard Nixon, is taking office, through the president, maybe in the next decade in the future, will be regarded as a regressive time with regard to liberty and equality. But I think we will, over time, go much further with regard to equality and liberty. A lot's going to depend on the accident of who gets to appoint justices to the Supreme Court. There were only 2 Democratic picks to the Supreme Court from 1969 until 2009. That's because Jimmy Carter didn't get to pick anyone for the Supreme Court, and President Clinton had 2. There were 2 Democratic picks and 12 Republican picks. Well, perhaps if there are Democrats or even Republicans who are appointing justices who are committed to advancing equality and liberty, this will all change. If we have presidents who are more committed to advancing equality and liberty, this will all change. I think it will. It's just a question of how long and whether it'll be in your and my lifetime.
When people come up now to be confirmed for the Supreme Court, they seem to very much incredibly trim their sails about anything they think. And I think it was most striking when Sandra Sotomayor had her confirmation hearing, and when she was asked a series of questions where she just said, well, basically, she just followed the law. And you could almost get the impression that following the law was like a math problem. That was 2 + 2 = 4. Talk a little bit about that, if you would.
John Roberts at his confirmation hearing said, justices are just like umpires. They just call balls and strikes. Sonia Sotomayor repeatedly said that justices just apply the law. They don't make the law. And so they're trying to make it seem that judges and justices have very little discretion. Frankly, I think both of them should be ashamed of themselves for giving the American public such a deceptive and inaccurate sense of what the law is. The reality is, every day, judges at all levels in the Supreme Court have to make decisions about which it's not like calling balls and strikes. Take cases about searches and arrests. What courts have to decide is, were the police acting reasonably? Umpires don't decide whether the first baseman was acting reasonably, or the catcher was acting reasonably, or whether it's a reasonable pitch. It's a discretion. Or the example we were talking about, what's cruel and unusual punishment? You can't find that out by just looking at a text. You can't find that out by looking at the rules of the game as you might in baseball. Judges have discretion in terms of that. Does racial segregation violate equal protection? Plessy versus Ferguson, the Supreme Court said no. Brown versus Board of Education, the court thankfully reversed and said yes. But you can't find the answer to that in the words equal protection law. And I think that the confirmation hearings are individuals saying what they need to in order to easily get confirmed. That John Roberts, Sonia Sotomayor felt, so long as they followed the script and said those things, Their confirmation would be easy. And they were right, but I think they could have also been confirmed if they would have been much more honest with the American people about what judges really do.
Right. Now, let me ask you about one case in particular from the last term of the court that people think may have a very transformative effect on the society, and that's the Citizens United case regarding, corporate contributions to election campaigns. Could you talk a little bit about that case and how it evolved and what you see as the possible impact? I know from the book you're definitely concerned about it.
I am, and I have to admit, after the first draft of the book was done, added some things about Citizens United. If I were to write the book today, I would include much more about Citizens United than timing allowed. And it illustrates what we were just talking about. The Constitution says Congress shall make no law abridging freedom of speech. I mean, this is a piece of the First Amendment. Is spending money in an election campaign speech? That's a judgment call the court has to make. And they actually made that call in 1976. Do corporations have free speech rights under the First Amendment? Until 1978, no Supreme Court case had ever said that corporations had speech rights. To what extent can corporations then claim a right to spend money in election campaigns? In two cases, in 1990 and in 2003, the Supreme Court said that state governments, federal government, can limit corporate spending in election campaigns. And the court gave important reasons for this. Protecting shareholders because it's their money that's being spent, preventing corporations from drowning out other voices, concern about large expenditures leading to corruption and the appearance of corruption. In January of 2010, the Supreme Court overruled the earlier cases. The Supreme Court 5-4 said that corporations can spend as much money as they want to get the candidates they choose elected, the candidates they oppose defeated. I think there's no way to see this other than in ideological terms, and I'm concerned about what it means because of what happened when corporations and unions can spend all they choose to get people elected or defeated. To me, it also shows that all of the talk about judicial activism is just a lot of rhetoric. Conservatives like to rail against judicial activism. I'm not sure what activism means other than the decisions we don't like. But if there's ever an activist decision, this is it. The court reached out to decide issues not presented before it. None of the parties asked the Supreme Court to overrule the other decisions. The court overruled precedent. The court articulated a broad rule that has no basis in the text or history of the Constitution. Now, none of that necessarily means it's wrong, but it sure is an activist decision.
Right. And just a couple of other things. One of the things I found most interesting about the book is that you articulate very clearly that the place of the court in our three branches of government. And you say that the court, in some respects, was designed by the founders to be counter-majoritarian, and that they're given life tenure, and that means that they're able to take risks to do things that somebody who's elected to office, or say an elected state judge, might fear to do. How do you think that the court's done in recent years in standing up to the challenges of protecting the rights of the disenfranchised or people that were otherwise thought poorly of, like immigrants?
I think the Constitution is inherently an anti-majoritarian document. What makes the Constitution different from all other laws is it's so much harder to change the Constitution. Of necessity, then, judicial review to enforce an anti-majoritarian document will be anti-majoritarian. And we give this task intentionally to federal judges who aren't elected and who have life tenure. I think the Supreme Court has had a mixed record with regard to protecting minorities. It is a court that has protected the rights of gays and lesbians, such in saying that the government can't criminally punish private consensual homosexual activity. On the other hand, it's a court that's dramatically cut back on the rights of criminal defendants, such as the Fourth and Fifth Amendment. There are few groups more politically powerless than that. It's a court that's imposed great new obstacles to desegregating schools. And I think that especially minority children are the victim of that, a group that has little in the way of political power. I think with regard to immigrants' rights, the decisions so far have certainly not been protective of immigrants' rights, though I think we'll see much more of that in the years ahead.
I'd like to thank Dean Chemerinsky for talking to us about his new book, which I found very illuminating, and I recommend it to all of you.